First case on this morning's docket, case number 115149, Reginald Stewart v. State of Kansas.
May it please the court, Michael Whalen on behalf of Mr. Stewart, and with the Chief Justice's permission, I would ask for 5 minutes rebuttal time.
5 minutes is granted.
Short background of the case. In 2015, Mr. Stewart filed a pro se 60-1507 petition. He alleged several issues. Some were alleged trial errors, some prosecutorial misconduct, and also ineffective assistance of counsel claims. After the filing of his pro se motion, the Chief Attorney of the Office of the Sedgwick County District Attorney's Office filed a 9-page response with 14 sections and I believe 28 subsections. That response was filed at 5:52 a.m. on January 26, 2015. 3 hours and 8 minutes later, the district court filed an order on the case denying the 1507, adopting the authorities and arguments of the state, and in particular paragraphs 7 through 14, as persuasive, and the petition was denied without further hearing. A notice of appeal was timely filed, and counsel was appointed, myself, to pursue the appeal. Now, the
Counselor, are you making? I didn't see any argument. You mentioned the time and time of the response and all of that. How does that impact anything here? Are you saying that was a due process violation because there wasn't time for a reply?
Well, yes, that was part of it.
And what's your authority for the right to file a reply?
Well,
you can only file a reply with leave of court, can't you?
Well, not being present or having counsel or representation, there was no way to have leave of court. And you know, there's a question I think that comes up is, how does the district court review the motions, files, and records of the case in order to say none of his stuff was legitimate in 3 hours and 8 minutes?
Well, that's not true, Counselor. That's not true. I thought there was an argument that it had languished for some time before the response was filed. The court had the motion, files, and records for maybe a year before the state's response, didn't it? I mean, it had it for a goodly amount of time before the state's response, right?
We don't know that, Your Honor.
Well, you know when it's filed.
Yes, Your Honor, but we don't know when the court looked at it.
Well, it had the opportunity to look at the motion, files, and records from and after the time that the motion was filed.
Correct, Your Honor.
And that was plenty of time for the court to have reviewed it.
Could be. Possible. But
well, whose burden is it? Whose burden is it here? Whose burden is it to establish that you have a substantial issue that requires a hearing?
It's mine, Your Honor.
Okay.
And I'm not saying that's my major issue. But under Supreme Court Rule 183M, if there is an appeal under one of these, counsel is to be appointed if the person is indigent. Now, the argument from the state and from the statutes and what's relied upon by the Court of Appeals is because this is a civil matter and because there is no hearing, there is no right to counsel. And that the submission of a writing or a formal, if you will, trial brief by the state does not attach any due process right or violate any right of the individual. Well, what's the difference? They have a right to counsel on appeal. Is it because, perhaps, that access to legal resources, the intricacies of putting forth argument and having the ability to present, as I am here today, to this court or to the Court of Appeals, requires skills and abilities? I mean, if we look at Mr. Stewart's petition, it is almost illegible. 30% of the words are misspelled. He is not educated. His legal resources are exceptionally limited. And this is an argument that I have advocated to this court before. And this is the problem, is we expect, and case law is rife with it, pro se litigants are expected to follow all of the laws, procedures, and the courts have the same expectations of them as they would of any attorney. But we are talking about individuals who are incarcerated, who are not educated, who, if I could skip ahead a little bit, in the case of Mr. Littlejohn, has an IQ of 49, or, in Mr. Stewart's case, obviously uneducated by taking a look at his pro se filing, with no assistance. Yet the state has a chief deputy attorney filing a written response with access, who has had 7 years of higher education and a doctorate.
Let's cut through that. Let's start with, so if your prisoner, your petitioner, has all these educational flaws, you're really arguing for a right to counsel simply to file the petition, aren't you?
No, Your Honor.
Because all those educational issues are present at the second they want to pursue an issue. And isn't the law pretty clear that there's no right of counsel to file?
Personally, Your Honor, yes, I would love that. But that is not what I'm advocating for here. What I'm advocating for is, if you are having an educated individual who is filing the response, I apologize, who is filing the response here.
You've got to kind of take this in a granular way and not throw a bunch of stuff into your argument. So so what you're complaining about is that the state filed a response through a lawyer, and you're saying that triggers a constitutional right to be able to have counsel appointed and file a reply to that response.
Yes, Your Honor.
And what's your authority for that?
The Court of Appeals ruling in Mr. Stewart's case.
And anything else? Is there any case law from this court?
From this court, no, Your Honor.
Is there any case law from the United States Supreme Court?
I don't believe so, Your Honor.
Okay.
And
you
quite
answer
honestly,
me?
from the...
Counsel, wait a minute.
Yes, Your Honor, I apologize.
Is there anything about, so the question in front of the district court is whether the record and the files present a substantial question, correct?
Yes, Your Honor.
Is there anything about the state filing a response that alters the record or the contents of the files that the court's supposed to make a decision about?
Well,
The answer to that is no. There's nothing that alters the record, right?
actually, let me take a step back, Your Honor. Article 8 of the Kansas Constitution Bill of Rights states that habeas corpus will not be suspended at any time. It is the only thing, aside from criminal cases, that is specifically mentioned in the Kansas Constitution. And what we have seen for years is the basic destruction and takeaway of the whole habeas process. Anytime there is any type of expansion, if you will, because now, at one time, Supreme Court Rule 183J meant something. The court was supposed to make journal entries that had findings of fact and conclusions of law. Well, since we switched to de novo review by the Court of Appeals, it doesn't matter whether or not the district court makes any findings whatsoever. Or if they make findings like here or in Littlejohn, where it's just an acknowledgement of what the state filed, the state is the one writing the journal entries here. It's not the court. The court adopted all of the state's findings. It wasn't an independent finding by the court. Same in Littlejohn. Littlejohn was word for word the journal entry from the state. So it's not just the state making an argument to the court. It is the state's representation and filing that is being adopted by the court. So it is the state that is dictating the findings of the court. So
So
yes,
your argument
there
is
is
that
an issue.
counsel,
Sorry, Your Honor.
when one of us is asking a question or you're answering it, we'll not interrupt, okay?
Yes, Your Honor.
So is your argument that the district court has ceded its authority to the state on making the determinations that are supposed to be made under 1507 and the rule?
In this case, yes. In the Littlejohn case, yes.
And your evidence of that is that the court adopted the suggestions of the state in its response.
Yes, Your Honor.
And does that depend upon the time frame in this particular case, or would you be making that argument anytime the court adopts the findings and conclusions presented by the state?
The time frame is not part of my argument on that, Your Honor. That's just from the journal entry by the court, specifically adopting every one of the findings, paragraph 7 through 14, presented by the state. And with no response. I mean, there were, within the Court of Appeals decision, there were several issues that they said these are just conclusory and were never spelled out. There were some odd, I would say, claims by Mr. Stewart. One of them was about petitioner's transcript results were likely to have been deliberate or the product of bad faith to convict and sentence the petitioner. It's kind of nonsensical, and I grant that. But if he had had counsel, perhaps it could have been explored or explained to the court what it was as a response to the state saying, this is nonsense, so this doesn't make sense.
And that's where I was headed here when you wound down is you make the allegation that there are facts or triable issues of fact that mandates a hearing, and which in turn would kick in the right to an attorney. And my question is, what are the facts? The way I read your argument is we don't know the facts, but we want to have a hearing so we can find out what the facts might be and what might support manifest injustice and what might support exceptional circumstances. And that's flipping the horse in the cart. The motion files and record is what is supposed to refute conclusively not entitled to relief, not have a hearing and go, oh well, there was nothing there. So what right do you have to have a fishing expedition to determine what your substantial issues and tribal issues of fact might be?
Our main argument on that point, Your Honor, granted, there's not much here. I think the main argument that we were looking at was the question of the issue of the expert witness related to eyewitness testimony.
And so that was your main, excuse me, I'm sorry to interrupt, but I want to get to the point because you're out of time. I want to get, your main concern here is the fact that the attorney should have anticipated that this might be an issue that would win down the road.
Yes, Your Honor.
Yeah. And do you, other than that, do you refute the Court of Appeals handling of the merits? The transcript he referred to, the failure to call the arresting officer, those issues. Are there any of those that you take exception to the how the Court of Appeals resolve those?
Two issues. One, we don't know if there's additional information related to the calling. The supposition of the Court of Appeals, or their resolve on that, was counsel had the opportunity to cross-examine the police officer, so there was no need to call him back. We don't know if there was an underlying issue there. As far as the other issues, no, necessarily not. Part of the issue that I do have is the Court of Appeals found that counsel should have been appointed. But we don't find an error because we're going to go ahead and just make our findings. If counsel had been appointed, the findings may have been different. If counsel had been there and argued on Mr. Stewart's behalf or had more information, because this wasn't just about what the state's response was. So we don't know that outcome. And so that's why I think, as far as this case and kind of the uniqueness of it on those facts and those findings of the Court of Appeals, that it seems kind of regressive and almost a punishment that there should have been counsel may have been helpful, but we're just going to ignore what the state said and analyze the case ourselves.
Which would be a de novo review of the motion, files, and records, which we say is our standard on review.
That's correct, Your Honor.
Yeah. Okay.
But counsel may have been beneficial and provided a different outcome had he been appointed.
When Justice Biles is pointing to a spectrum, I assume you don't have a right to counsel upon confinement of a prisoner. You say there's not a right that attaches upon the filing. We have a lot of cases this morning dealing with this issue. Do you have like just a general concept of when the right to a counsel attaches when a 1507 is filed?
I believe it is when either the state engages by filing a motion, or if the court finds there's a substantial issue. But this would be a completely different case.
Do those both arise under the statute? Or is one statutory, one constitutional, or are they both constitutional?
One constitutional, one statutory, and also case law of this court.
The state's response giving rise to the constitutional right and the statute giving rise when there's a substantial issue, is that your position? Okay.
Yes, Your Honor.
And where does our case law fall under that?
Okay.
As to the interpretation of the statute only? Or do you have some constitutional case law that you point to?
This is really it's a matter of first impression. And the due process analysis really comes from, we have an unrepresented individual who's really incapable of standing up against the state, who is presenting case law and analysis in a manner that that individual cannot do and is not allowed to review or respond or deal with in any manner. And what we find is the court is then just flatly adopting
the views of the state without review.
And that due process right is procedural due process? I didn't see any argument you made as to why there's a substantive due process right in play here.
I think it is substantive, and I think it goes back
Well,
to...
you didn't argue that, did you? Or
I felt it was implied, Your Honor.
Okay, we're supposed to intuit that whichever due process fits? I mean, isn't it incumbent on you to show us if it's an issue of first impression, to lay it out and explain why it should apply?
I felt that we did, because it had to do with it, that I don't think there was any implication within the brief or the petition for review that this had to do with procedure. All of this was substantive. I mean, our entire argument is about the fact that these are individuals who are incapable, that there's no difference between having a hearing and requiring counsel to represent them against the state, and the state and an attorney, a learned attorney, filing a substantive written ruling
So,
for the
Counselor,
court.
your complaint is the procedure employed, that is, considering the state's response without appointing an attorney to file a reply, that procedure is fundamentally unfair. That's your argument?
I don't believe that's procedural, Your Honor. I think it's the...
Well, is that your argument? That's what I'm hearing you say, that
The
it's fundamentally unfair to let the state file a response and not appoint an attorney to respond to the response. Is that your argument?
Yes, because it violates the individual's ability to be a part of the judicial decision. That's the substance. Because I don't believe
And
that...
are there courts that have held a substantive due process right to appointed counsel in a habeas case? Or are you first impression for us or first impression across the country?
I'm not aware of any other areas where this has come up.
In fact, the U.S. Supreme Court has said the 14th Amendment does not provide that a post-conviction movant is entitled to counsel.
Correct.
I mean, basically said there is no right under the 14th Amendment. And I don't see where you've argued a constitutional right to post-conviction attorney. This is all statutory. The only time we've talked about the right to counsel in 1507s is in terms of the statutory right. And we have a statute, 224506, that provides, and so I don't know where we get the constitutional argument. I didn't see how you tied that together.
Because I believe it's the equivalent of the statutory right, and there's a reason for the statutory right.
Do we have any more questions? Thank you, counsel.
Thank you, Your Honor. Justice Files, I apologize if I was impertinent.
May it please the court, Assistant District Attorney Boyd Ishwood on behalf of the state of Kansas, and maybe it's maybe it's that I can't read real well, or maybe I'm not real smart, but I didn't see 3/4 of what was just talked about in Mr. Whalen's petition. The issue, as I understood it, on which the petition was granted, dealt, as Justice Johnson has indicated, with the statutory right, and when that statutory right to assistance of counsel would attach into 1507. And to answer Justice Rosen's question, if I could see better, I have to put my glasses on, but to answer Justice Rosen's question, the way that I understand, Mr. Whalen is asking for a new law You have a rule, you have a law, you have case law about this issue. And when you look at it, it reduces to the following. When the district court judge, when we can tell objectively that the district court judge has subjectively determined that there is a potential substantial issue, then counsel needs to be appointed.
Is that right under the statute?
I believe it is correct.
Well, that's what our case law talks about, potential substantial issues, but the statute just doesn't use the word potential, right?
Well,
That's my question.
And as we'll find out, I'm sure in the later cases today, you know, this court interprets the statutes. This has been the interpretation.
Sure, I'm asking, is the state, I guess it sounds like you're saying you're willing to live with that interpretation.
I think that's fair.
Okay.
I believe that to be fair, and that's the way that we've operated for a number of decades, as near as I can figure, and that would be fair. You know, we're not.
So again, just to pin down where we are, the state's position is it's okay with the word potential being added to the statutory language.
I think so.
Okay.
And I think it almost has to be, because that acknowledges a real world practice of what's happening. I don't think that the court was wrong when that interpretation was included in the case law years ago. I'm sorry, Your Honor.
No, y'all want you to finish that.
Okay. Well, what I was going to say is I think we'll find out in the later arguments. But I think that's the governing principle here. It's a statutory right. That's when it attached. All we're asking you to do is follow that rule in this case. So the issue comes up: what import, if any, is there with respect to the state filing a response? That's the issue that is.
And just to remind me, because we do have a bunch of
Sure.
cases in a row on the same. In this particular case, the state spontaneously filed that response, or was asked to do so?
Objectively, I believe in this case, and I have many as well, Mr. Whalen may correct us, but I think in this case there was no request.
Okay, the state just spontaneously, after several months, filed a response.
There was, yeah, to my knowledge, there was no specific request in this case.
Okay,
And I think what happens is
Go ahead.
I think what happens is we're going to find ourselves in a situation where we have three different things that can occur. As Justice Beyer indicated, one, a spontaneous request. Two, a request after district court judges asked for a request. And then three, a situation that we're going to see later today where the 1507 has multiple issues. The district court judge resolves some of the issues on his or her own and then asks for a request. And to me, if you go back to what I posited as our working rubric, if we can objectively determine from everything that we have available to us that the district court judge has subjectively determined that there's a potential substantial issue, counsel needs to be appointed. That is our later case this afternoon, which we take no issue with.
Doesn't the statute give us an objective basis to make that determination?
I'm sorry?
Doesn't the statute give us an objective basis to make the determination by the opening sentence, which is unless the motion and files conclusively show the prisoner is entitled to no relief, the court shall cause notice thereof to be served on the county attorney.
And I
So
think
anytime the court has service on the county attorney, we have an objective standard, objectively can determine that the standard has been met?
no, I think we need to look at what the district court judge has determined.
What is the meaning of that then, if the judge decides to make sure notice is given?
Well, I don't equate, I guess, notice being given.
What does
With-
that statutory language mean then? The court shall cause notice thereof to be served. If the motion doesn't have substance, then the court doesn't have service accomplished.
If I'm following what you're saying, if I'm understanding, I think that I've always read the provision that you're referring to as just indicating that the district court judge has a duty to include the state as an opposing party in the mix. That's all I've ever taken that to mean.
And we have potentially contradictory statutory language, don't we? At 224506 B says if the court finds that the petition or motion presents substantial questions of law or triable issues of fact, and if the petitioner or movement has been determined to be indigent, the court shall appoint counsel. And so that says substantial questions of law or tribal issues. I guess the determination would be, is that the same as determines that conclusively entitled to no relief?
Or the converse, basically.
Yeah.
There might be something there.
But there's, that doesn't,
To me,
not
that
every
seems-
time that you're going to have an evidentiary hearing, is it gonna resolve it one way or the other? And so
That's-
conclusively not entitled to relief, to me, I don't know that I equate that with substantial, questions of law or tribal issues of fact. And if they're not equivalent, then how do we, interpret those in materia, the 2245-06B and 1507A or whatever.
And I think that your case law has done that, whether it was intentional or not, by including the potential, indicating that counsel should be appointed when there's a potential issue. I think if I'm understanding you correctly, you're suggesting that every time we have a hearing, there isn't going to be found a substantial issue because sometimes you will fail.
Which leads me into my next question here. The way I understand it, you're saying that if we can tell that the judge has determined that there's a potential substantial issue, then we need to have counsel appointed. But I think part of our problem here is we've kind of put a temporal limitation on that determination has to be made when the motion comes in. And I guess the question is the motion comes in, the court looks at it, isn't certain whether it conclusively shows, gets a response from the state. I think the only way you get there is gets a response from the state and uses that response not to determine the merits, but to determine the existence of a substantial issue of law or tribal issue of fact.
Well,
You see what I'm saying?
Well, I think somewhat, but I think there needs to be a real world workable solution to this, and the district court judge, obviously the district court judge will receive the motion, let's say on Monday at 4 p.m. Why would the court need to resolve it at that time? There's no, and I guess maybe the bigger question here is why would the state be entitled to respond to the motion in and of itself? And I think that question is even wrong. Why wouldn't the state be able to respond to a motion? As we indicated in our petition, there's no indication this is an ex parte proceeding. There's every indication from case law, from statutory authority, just the fact that this is a civil setting, that as a party, the state should be able to respond. And I don't think that necessarily in and of itself would trigger the need for an attorney on the other side, because you do have your prior cases that indicate when that occurs.
This is weird, obviously, because it's a civil proceeding, but the state is both the lawyer for the party and the party. I mean, it's just a odd duck, and so that kind of complicates Mr. Whalen's argument. How else is the party going to respond other than by the prosecutor filing something as both kind of
Maybe
as the party?
Yeah, I don't know the import of that on the issue of whether the movement would be entitled to statutorily entitled to counsel.
It just makes it more complicated for him.
I think I wasn't making myself clear. It seems to me that we're all in agreement that before an attorney must be appointed statutorily under whichever statute, a judge has to make a determination there are potential issues of law that are substantial. We all agree with that. And then my question is, when does that determination have to be made? The argument is, I think from opposing counsel, that decision has to be made before you get a state's response. And my question was, to you is, obviously you don't think so, and why is it you don't think so within the terms of Chapter 22 statute, the 1507, our rules?
There's nothing that.
Give me that argument as to why the court can receive a response from the state to make the determination of the substance of the claims versus the merits of the claim. You understand?
Because I just believe it's part of the motions, files, and records of the case. There's no indication that there's no indication that they wouldn't be able to. In fact, there's every indication that they should be able to. It's because becomes part of the motions, files, and records of the case. And if that doesn't answer the question, I apologize.
Because it's
But
responsive to the motion that's been filed.
That's correct.
Because you're acting as a regular civil litigant?
We're acting as a party.
Well, right, a party to a civil lawsuit.
I don't see it any different than, maybe, again, I'm not the sharpest knife in the drawer, but I don't see it any different than a trial setting where the judge takes input from both sides. This side happens to be the state in this setting, and this side happens to be the pro se litigant who is not yet entitled. There's been no determination that they are yet entitled to an attorney.
Let me ask a slightly different question that piggybacks off what you just said. In Chapter 22, the right to counsel, statutory right to counsel, it talks about if the court finds. Do we need to have a finding in the lower court before we can have effective appellate review? And then part B of that question is, what would our standard of review be over the finding or lack thereof?
Finding that counsel is required.
No, the finding that the statute refers to, i.e. that the petition or motion presents substantial questions of law or tribal issues of fact.
Which would be the same finding that would be required for appointment of counsel.
Yeah,
So
that's what triggers it.
It's a
triggering finding.
And
right?
the first part of the question was.
Well, I'm asking again. It's a slightly different question, referring specifically to this idea of a finding. Do we
need a finding?
Do we need a finding before we can even review or answer this question?
Well, the finding, I think, would, unless I'm not following, the finding, I think, would be implicitly made there because either counsel would be
that's the
appointed or
problem.
counsel wouldn't. And then what would the standard of review be? I believe it would be de novo.
If the lower court appoints counsel, implicitly the lower court made the necessary findings, but we're not going to be reviewing that. We only see the cases where there was no counsel appointed.
That's correct, which I think kind of dovetails into the.
And so, does that mean we should presume that the court made a negative finding?
Yeah.
And if
That's
so,
only one
what's our
possible.
standard of review?
Okay.
Well, I think if we have a summary denial that under 183F, that is in effect a finding that the motion, files, and records conclusively show the movement is entitled to no relief, because statutorily that's the finding that has to be made for a summary denial, isn't it?
Yes. But I would like to,
Is that the same finding that would be after the state's notified? Because of subsection, it says prompt hearing and notify the Court of Appeal.
the Court of
I
Appeals.
mean, the district attorney or county attorney.
Yeah.
And so that's, once you're notified, then that's also indicates that, as Justice Luckert says, that the court didn't make that finding.
I don't read the statute to indicate that I don't read the statute that the district court is to notify the state of the filing only if it has made a determination as to whether there are substantial issues or not. I don't read it that way. I would like to, if I can.
Can I get you to return to Justice Stiegel's question for a moment, because I'm not sure you got a complete answer out, and I think, if I may, just add to it a little bit. He's saying, I think he's trying to just direct you just to 4506 and that introductory language that we just talked about as the triggering finding for appointment of counsel, that the court finds there's a substantial issue of trial. Okay, so we're on the same page there. It seems to me that when a case arrives here and no counsel was appointed, there's really the possibility of only two scenarios. And one is an implicit, this is the one that Justice Stiegel was suggesting, an implicit finding, even if it's not expressed, but an implicit finding that there was no triable issue. And that's why I didn't appoint counsel. So that's one possibility. But there is, at least in theory, another possibility, which is I failed to make the finding. And I think that's what you're getting at,
Correct.
isn't it, Justice Stiegel?
Yes.
So talking about the practicalities here,
Mhm.
which I'm sympathetic to, would it be good if we said that statute means you ought to make an explicit finding so we know what the heck happened when it gets here? Because
Well,
as he said, we're only going to see him when somebody's complaining, I should have been appointed counsel.
And I think, and maybe if I don't answer that in the next couple minutes, maybe you hit me over the head and we go back to it again. But I think
Okay.
maybe that all gets resolved by the ultimate test on appeal being harmless error. And we go and we look and see if there was any substantial impact on this decision on the case.
We get there if we do like we do in many cases where we say, assuming this was error, assuming this, assuming, and we make a bunch of
Right.
assumptions.
And
Then we say we still lose. But
I
I'm
think
trying to get you to just focus on that one question. Would it be better if
we would
when
certainly.
we ultimately issue an opinion, we say to the trial court, take another look at 4506B. It says you have to make a finding. It'd be really helpful on appeal if you made it explicit.
Well, we would certainly know exactly what we're dealing with
Yeah.
if that were to be the case.
Did that cover what
Yes,
you were
and then
trying to
just my last follow-up to that on the question of standard of review. Should that be a de novo? Let's say there is a finding. Let's say the district court explicitly in the record, I make a finding that the petition and motion does not present a substantial question, so I decline to appoint counsel. Would that ruling be reviewed on appeal de novo, or is it discretionary?
Well, I don't know how it would be reviewed any other way than de novo, since the ultimate conclusion is going to be reviewed de novo as to whether they were entitled.
Usually on a finding, though, a finding of fact, if this is a finding of fact,
That's the question.
it
Is
would be
pure law
substantial
or-
competent evidence
Right.
to support the finding. So that's an interesting question, but
Well, yeah, I think it seems like it's a question of fact and law.
yeah.
If there's a mix of fact in there, typically we would review for abuse of discretion.
Well, I think we've been through the change in 60-1507 from the standard of abuse of discretion onto de novo. So ultimately, even though it may not support my position all the time, I think we're going to end up in de novo standard of review.
On the merits, that's totally different from the appointment
Okay.
of counsel, though.
To directly answer your question, I guess I don't know.
I've
Because
got
you
a
know.
quick factual question, Chief, if I might.
Yes.
It looks like to me that both the state and the Court of Appeals was a little confused about the complaint of trial attorney not calling the arresting officer. That you're talking about Officer Miller on the first trial, and we had 3 trials here. And that the arresting officer that took the defendant's hat that he was complaining about was Officer Estrada, and he did not testify at the 3rd trial, and I think that was the complaint, and so the rationale for why that had no wasn't an issue. Because Officer Miller did testify, didn't answer that claim. Do you have anything real quick as to why Officer Estrada's, the failure of trial attorney to call Officer Estrada to say he took his hat off, that all had to do with the eyewitness at the 3rd trial, can be summarily dismissed.
If I'm understanding you correctly, and I'll just have to concede that that's because this is the first I'm hearing of it, is you're indicating that everyone got it wrong. And that includes the district court and the court of appeals when they said it's no big deal because this person did testify and was subject to cross-examination, but apparently they had the wrong officer. The only thing that I can offer to you quickly on that would be, I think that issue could also be taken care of through harmless error at this stage. Could be taken care of through harmless error. I don't necessarily recall from a review of petition exactly what it is that they indicated that this officer, what the impact. My understanding was, regardless of what officer it was, there in the initial petition there was no indication of what the impact would have been, so it would be conclusory.
Right.
Counsel, what are you asking us to do in conclusion?
Follow your law. That's what I'm asking you to do. I'll be doing that a lot today.
What result would that give you?
I'm sorry?
What result would that give you in this case?
In this particular case,
Yes.
I think, is this the one where the Court of Appeals indicated that you get an attorney automatically basically when a response is filed? What result would it get us? And the district court would be affirmed.
You cross petition on the Court of Appeals saying that it was error not to appoint an attorney, but it was harmless because they could review without the state's response and it would be the same result. So what you're wanting us to do in this case is to overrule that paragraph of the Court of Appeals opinion that said the district court erred in not appointing. Is that?
That's correct.
Yeah, okay.
Thank you, counsel.
Thank you.
Excuse me.
Could you address Justice Johnson's question? Because I think it does present a very practical scenario for a lot of district court judges. I can include myself when I encountered this, and that is the import of the states filing a response. Many times, you know, you're sitting there as a trial judge, you have stacked stuff, you have jury trials going on, and you get these motions, you look at, you set aside time to do it, you look at it and say, most of this I can decide, but, well, I don't have the time or the just trying to expend where I need to spend my resources. Let me hear what the state has to say before I determine whether or not this is a potential substantial issue. What's wrong with that, and why would that trigger a right to counsel? I'm assuming as soon as I made that determination that I want the state's input just to see on a particular issue, your position would be that triggers the right to counsel.
Well, the state is an advocate for.
The state's a party.
It's both a party and an advocate.
Right, that's the difference.
That's the odd duck.
I want to hear from a party. The motion's been filed. I want to hear what the other side has to say before I make this determination. I think I know where I'm going, but let me see if I'm missing something.
May I say,
Yeah.
why is the response to the motion not part of the motion, files, and records of the case? As
Basically
your-
the same question.
Yeah, that's exactly.
Yeah,
That's just
same
saying it
question,
another way.
Well, and I think everybody's confused about that, quite honestly, because I've seen, I think, both in the Court of Appeals. I mean, and I think, like Mr. Isherwood, some of these cases are starting to run together a little bit. But I've always considered the motion, files, and record of the case to be the underlying criminal case and its record.
Yes.
I mean, I've never considered that to be the petition and responses and what was going on in the civil case.
What is the motion? In 1507B,
Motion,
isn't the
records,
motion?
files.
Yeah, what is the motion when it mentions that? Isn't it has to be the motion under 1507, doesn't it? I mean,
I
it's
just always
only
presume-
a motion. So what other motion would it be referenced?
Well, then, if it's singular, then it excludes anything from the state.
Not necessarily,
If
because
it's-
the motion practice includes responses and replies on a motion. In the ordinary case, if you've got a motion, typically you get a response and even possibly a reply gets filed depending on what's authorized. But why wouldn't the pleadings on that motion be included in that word in that statute?
Oh.
That's
Because
what your
we
opponent's
presume-
argument is.
Because we presume the legislature knows what they're writing, And if they had said motion and response or motions, I think they may have considered that. But if it's motion singular and then files and records of the case, then they weren't contemplating a response by the state. And if we look at, there isn't anything in the statutes or case law that necessarily considers a filing from the state. I mean, as the court pointed out, the court, if there's a finding of a substantial issue, the court will notify the state. When presented with a 1507 motion, the district court has three options. It can determine the motion, files, and records of the case conclusively show the petitioner is entitled to no relief, in which case it will summarily deny the petitioner's motion. No contemplation of input from the state. Second, the court may determine from the motion, files, and records a substantial issue or issues presented require a full evidentiary hearing with the presence of the petitioner. Third, the court may determine a potential issue or issues of facts are raised in the motion, supported by the files and records, and hold a preliminary hearing after appointment of counsel to determine whether in fact the issues in the motion are substantial. And that's from Lehman and also quoted in Guillory. And if we look at Rule 183, when a motion is filed or provides hearings, unless the motion to vacate, set aside, or correct the sentence in the files and records of the case, and the sentencing court conclusively show the movement is entitled to relief, the court must grant a prompt hearing and notify the county or district attorney. So both within the court case law, statute, and this court's rules, there's no contemplation of the state doing anything until the court invites them in. And that is based upon a finding of the substantial or potential substantial issue. I mean, I don't think we would be standing here if the court had looked at it and said, I make a finding, there are no substantial issues and I deny. And it was a summary denial.
Until the state is invited in, it's not an ex parte motion, is it? It's not just a. And I
No,
understand
this was not, and that's not a claim. I mean, I don't believe that the district court said, I agree with Mr. Isherwood. This wasn't, hey, would you write something for me? In Sedgwick County, the majority of the time, almost all 1507s that are submitted to whoever the main judge is handling, and this has been in practice for years, the state will file a response. And whether or not, without the invitation of the court.
And so is it your argument that the state is precluded from doing that, from having that practice?
Yes, Your Honor, until such time that the court makes a determination that they should be involved in the case. And I recognize...
And your statutory basis for that is, I assume, under 183F?
Yes, Your Honor.
But
and also
how
22.
It says unless the basically court finds conclusively the movant's entitled to no relief, the court must grant a prompt hearing and notify the county or district attorney. Now, you're saying that means notify the county or district attorney about the motion. Why isn't that equally interpreted to mean to notify the county or district attorney of the hearing? Because it must grant a prompt hearing and notify the county or district attorney. That doesn't mean that's the first time that the state gets to know about the motion existing, does it? I mean, when you read that in context, the notification is of the prompt hearing, not the fact that a motion was filed. And unless we go there, I don't see any place else where the state is not entitled to know that a motion was filed.
No, I think I don't disagree with that reading, Your Honor.
What about
I can see that context.
what about that language I quoted from 60-1507B? How does that impact? It starts with, unless the motion and files and records of the case conclusively show the prisoner is entitled to no relief, the court shall cause notice thereof. I assume that's the motion. And the predicate is there's a finding about whether there's substantial, or whether there conclusively shows that entitled to no relief.
I concur with that, Your Honor. But in another contrast and conflict is Court Rule 183A4 states when a motion is filed, the clerk must serve a copy of the motion on the county or district attorney and complete a certificate of service. I mean, when?
What's the point in notifying the state of the motion being filed? Advisory?
I'm not against the state being notified, but the court's case law, and I think the rest, if we read all the other rules and everything else together, the state doesn't take action until the court makes a determination.
Thank you.
And unless there's anything else, thank you, Your Honors.
Thank you, counsel. We thank you both for your arguments on this case this morning.